ACR Concrete and Asphalt ADA Design and Build. Today again we're debunking one of the more common myths that are out there and one of the popular topics. My name is Anthony Gashard. I'm the principal of ACR and the founder. Today we have team member who's our CASp inspector, Jason. Again, his number's down in the 400s. He's a DSA inspector. His daily chores take him to inspecting ramps, railings, signage, detectable warning domes at some of the highest level projects, our major universities, our schools. He is a DSA inspector along with being a DSA CASp inspector. So that puts Jason at the top of the list in his field, which is why he's part of ACR's team. Jason is not an employee of ACR. If he was, then it would be creating a conflict. We need Jason to be independent, so then when he reviews our work, he can come to us in good faith and state, hey, something's wrong, I need a little tweak over here, I need a little correction, or maybe an additional sign over here. So we have to satisfy Jason, who's looking at this with a magnifying glass. So that's what makes him an excellent part of our team, because he's the toughest in the business. In addition to that, we have ADA legal counsel. In the event you get caught up in one of these lawsuits, she does not work for a flat fee. We believe that the flat fee oftentimes is not in the client's best interest. She works against these aggressive plaintiffs on a daily basis. And again, she's not an employee of ACR. She's part of our team. The team is a critical component. So if you're caught up in something and you need to review your ADA situation with a lawsuit, then we have the capability of taking it from point A to point B. So today we're going to be talking about another item, which is a particular client, as an example, has been caught up in an ADA lawsuit. They have a CASp inspector and their attorney has told them, you don't have to make that correction because it just won't work. It's physically impossible. So claim a physical hardship. In my opinion, and Jason can elaborate on his experience, but my opinion, out of all the properties that I've been to, and I'm an ADA designer, contractor, I understand the law completely. I know what the allegations that are being claimed by all of the attorneys that are out there, so I take all of that into consideration. Disbursement of the ADA parking stalls, I take all of that into consideration when I put our design together. When I finish with the design, I run it through Jason's set of eyes too, so there's another layer there. But very rarely have I run across a property that I can't build a ramp or that I can't make accessible. So, give you an example, one item that I'm currently working on right now in the city of Downey is that based on the existing situation and the height of the building as it meets the city sidewalk, we can only draw a straight line. We can't make all of the items or the barriers comply to federal and California code. It's physically impossible. But the way that we determine that it's physically impossible, a contractor cannot make that determination. An architect can assist you in making that. A civil engineer can assist you. An attorney cannot make that determination. The only way that I can see, and according to Division 2, I believe, and you can correct me if I'm wrong here, Jason, but a Division 2 scoping, it talks about technically infeasible. And it states that if you can't meet the code, then you need to do best case scenario. But local authority or the enforcing agency makes that determination. So the project that I'm currently working on, I've put together, I've surveyed it, I've performed the civil engineering on it, I've gone back and forth. I cannot meet the code to the letter of the law. In my opinion, if I can't do it, nobody can do it. So I've gone to the city has reviewed the plans, we debate back and forth. We bring our CASp inspector in, Jason, and we all talk about this because we want to arrive at the best case scenario. We want local authority to approve it, or the enforcing agency to say, hey, you guys have exhausted all the efforts out there. So we're going to stamp these plans and you construct it as the best case scenario. So now there's a document So if someone comes back 5 years from now and says, hey, you didn't meet this code, we come back to these plans, there's a record of it, and the local authority, meaning the city, has approved it through a series of plan checks and scenarios. So never rely on a contractor who is telling you that it won't work. You want to work with in my opinion, you want to work with an ADA designer, such as myself, who will work with the CASp inspector, say, this is best case scenario, present formal drawings, have the city review it, have it debated, and then ultimately you have the best case scenario or application for that property. But I'm sure you're running across this all the time too, and contractors are stating that, hey, it just can't be built. And so what are you stating?
Yeah, all the time. And to elaborate on your point, not even a CASp inspector can tell you if it's incapable. Like Tony said, you want a designer, you want a civil engineer at the very least, a designer. One of the things that I run into a lot is, we'll say a restaurant or a nail salon required to have a restroom and the restroom's too small. And they feel like because they have to move walls that it's technically infeasible. The ADA code doesn't say that. It says structural walls. These strip malls that you have, these core and shell buildings, only the dividing walls and the exterior walls are structural. You've got screen walls in there that go up just barely above the ceiling. They're not structural, they can be moved. The other thing I wanted to elaborate on is when something is technically infeasible, the ADA states that you must become as accessible as to the maximum extent feasible. But the California Building Code states if something is technically infeasible, equivalent facilitation has to be provided. And that's where it gets a little tough. When you can't get an entrance into a building and you have to figure out a way to provide equivalent facilitation, or if the walls to the restroom are structural and you can't get them moved, you have to figure out equivalent facilitation, or you're looking at another lawsuit, obviously.
So if you're wanting, and you're right, these restrooms are always a problem because they're 3 by 5. And now if you run into a 3 by 5 and the outside wall is a structural wall, what are your thoughts? What?
Per the ADA standards, it's technically infeasible. If you have to move a structural member, then section 202.3 of the ADA states that it's technically infeasible, and other means must be found.
What's the alternative? And just, you can't put a porta potty out there. I'm just wondering what the alternative. If they have 2 restrooms, oftentimes you can take out that interior wall and then come in and make it one big all gender unisex and make it compliant. But
depending on capacity of the restaurant, and that's why I stress that you need to get a designer that knows the health and safety codes, knows the capacity codes. Sometimes you're encroaching into a kitchen.
Exactly.
Sometimes, but if all you're doing is losing a table or a nail station, unfortunately, there's not a whole lot that can be done in your favor.
So going back to who decides that it really is in documentation, my belief is that, hey, we're going to this restroom, we can't make it compliant because we have to move that exterior wall that is structural. So according to ADA, it's technically infeasible, but local jurisdiction should be the determining factor. Right. So you should put a series of plans together and say, hey, look, according to ADA standard, section 202, what have you, then this is technically infeasible. Get the city to stamp that plan so there's a record of it. Because if a contractor comes in and says, it's technically infeasible, you can get sued again without that documentation.
Yeah, and the code always refers back to the authority having jurisdiction,
exactly.
Which is the city planning department, building department.
Okay. Hey, great information, good stuff today, and I hope that clarified a lot of your concerns. Keep in mind, you can bypass all of these steps by simply making your property compliant the first time. The ACR can assist you with that, starting with the CASp report, going into the design, formal plans, inspection by the city, CASp re-inspection, and I believe we're the only guy in California that's raising their hand to have their work inspected. We want that because our clients are now given another layer of protection. And we don't charge our clients anything additional for that CASp re-inspection, by the way. It's something that we want, and we pride ourselves on providing quality and perfect work. So again, any questions, feel free to give us a call or send me an email. We'll be more than happy to get back to you and answer all your questions.